What is the process of claiming asylum in Israel for African refugees? Hi, my name is Joshua Pex. I'm an Israeli immigration lawyer, and I'm going to tell you a short story about an African asylum seeker from Nigeria who requested refugee status in Israel. So first of all, you have to understand that Israel is a signatory of the International Convention for Refugees of the United Nations and also the protocol from '67. But when it comes down to it, the most important legal aspect is that Israel itself has a procedure of determining status for refugees, and the Israeli immigration authorities need to abide by this procedure. So in our case, we have a Nigerian refugee that came into Israel as a pilgrim with a tourist visa. Shortly after he arrived, he went to the RSD unit within the immigration office. RSD stands for Refugee Status Determination, filled out a form and applied for refugee status. Now he did this in accordance with the Israeli procedure because this needs to be done within 1 year of entering Israel. So he filed the application, and what happens that in the meantime, these kind of cases that are pending will usually receive what is called a temporary visa, and this is not a work visa, but in all practicality it allows these asylum seekers to work until their status is determined. And the way it's determined is that the Israeli immigration conducts the interview. They also check what is the basis for the application and try to verify the facts of the case. Well, in this case, it was a good application because it did point to one of the indicators in the convention, which is political persecution. So you have to understand that the convention and also the Israeli procedure has a list of different criteria, and an application needs to fit one of these criteria. So if a person asked for asylum just because there's hunger, a famine in their country, or maybe even some natural disasters, none of these cases fit the Convention of Refugee Status. So even if the situation in the homeland is very, very difficult, if the application doesn't meet one of the criteria of the convention, then it will be immediately denied. Well, in this case, the good news was that he did apply for political reasons. What he said that in his homeland, he's being persecuted by the government because of his political activity within a certain organization that is being persecuted by the government. So he made the application, got a temporary visa, and then the waiting started. He waited a long time, and again, it's not unusual to wait for years and years. He applied in 2018, had an interview, had another interview, but the years passed, and he contacted me only after he received a very short decision that his application was denied. So when I saw the letter of denial, it just very, very shortly, imagine a person applies, goes through the interview, waits for years, and then gets a very short letter. Your application was denied. You need to leave Israel within 30 days or else appeal. So I met him, I looked at the application, I asked him what questions was he asked in the interview, and I understood that he has a strong application, but relatively little evidence, objective evidence to support his application. And anyway, I found out that the denial process was not done exactly according to the Ministry of Interior procedure itself. So I already had a sense that we can actually win the case in court, because one of the best ways is to show that the state itself, the immigration office itself, didn't conduct its process according to their own procedure. But first of all, I told him, your application is a good application. You say you've been involved in all kinds of political activities, that you're being persecuted. But if you had any kind of external support, objective documents, anything, it would very, very much strengthen the application, because at the moment all you have is what you're saying, which is good. And in some cases, refugees can't come up with any external evidence. But he went back, he contacted the organization, he tried to find more information, and he did manage to come up with at least 2 pieces of evidence. Again, they were not very strong. In these cases it's administrative law, so you show all kinds of documents. But anyway, it's something which is very, very good to have more than just, the story. And the other thing was that I saw very clearly from reviewing the case that the Ministry of Interior itself, breached their own laws, basically, by not conducting the process according to that procedure. So with this, we went to court. You need to file very quickly an appeal to the Administrative Court of Appeals Tribunal, according to the law of entrance to Israel. You need to sign all kinds of documents, prepare the application, prepare affidavits, bring other witnesses as possible, anything you have. And the application needs to be submitted within 30 days. The most important part is getting an injunction order to prevent deportation, because even though it sounds maybe strange, but filing the appeal doesn't necessarily prevent deportation. And if a person's visa is expired and he's actually deported outside of Israel, then the whole appeal process and the court process, is no longer even relevant. So in order to get the injunction order, the judge agreed, but said you need to put a bank deposit of 7,000 shekels, which was pretty much a lot of money for this asylum seeker. He came up with the money. We went to the Minister of Interior's office to place the bank guarantee, and this is done at the airport, the Ben Gurion airport. It's another bureaucratic procedure. You put even cash, you can submit cash. We got the injunction order, which was a very, very good stage. First, success, because once you get that, you know that the person won't be deported as long as the case is in court is pending. And the judge gave the Minister of Interior lawyers 30 days to reply to our appeal. And very quickly, I think that the lawyers representing the immigration office reviewed the case and saw what I also saw from the beginning, that they themselves breached their own procedure. So I got a phone call from the lawyer representing the immigration office trying to get to an agreement to dismiss the case and send the asylum seeker with the new evidence he had to another interview to reassess the case. So in a way, this is a success, because now the case is going back to the stage of refugee status determination. I also wanted to get court fees, because this person was actually denied his application unjustly. So we asked for the return of court fees, which unfortunately we were rejected. He did get back the 7,000 shekels bank guarantee, which was good news. And now we're going back again to have his refugee application reviewed in the same place with a little bit more evidence, and hopefully this time the application for asylum will be accepted. Again, most of the applications are rejected. Even with this new evidence, it could be again rejected, and then we'll need to go back to court again. So this is one story that explains you the process of refugee status determination in the Israeli immigration system. Thank you for listening.